Hi, I'm Stefanie Tate, an associate at Nichols Family Lawyers, a boutique specialist provider of family law services with offices in both Melbourne and Geelong. Today we're going to dive into the do's and don'ts of high asset divorce, also known as high net worth divorce. These types of matters involve the separation of couples with large financial assets, and they often come with unique issues that require careful legal guidance. One of the most critical don'ts during financial separation is attempting to hide assets. In family law, both parties have a legal obligation to provide full and frank disclosure of their financial circumstances. This includes not just what they own directly, but also any indirect interests, like those held through companies, trusts, or other entities. Disclosure must be complete and ongoing. As circumstances change or new documents come to light, they must be shared with the other party and the court. This means providing items like tax returns, bank statements, superannuation details, and records of any interest in trusts or companies. Failing to disclose isn't just frowned upon, it can lead to serious consequences. Uncertainty around asset transparency can create real challenges for both parties and their legal representative. In fact, if you're found in contempt of court by way of not providing complete disclosure, penalties may include part or all of your case being dismissed, cost orders made against you, or even fines or imprisonment. Don't let your emotions get the best of you. Do your best to stay calm and composed. Separation is an emotionally intense time, and it's easy to act on impulse or let frustration dictate your behaviour. However, every message, conversation, or action taken in the heat of the moment can have lasting consequences, especially if the matter ends up before the court. Taking a moment to pause, reflect, and seek legal advice before responding can help protect your interests and avoid unnecessary complications down the track. Don't become financially impulsive. During a financial settlement, it's important to avoid spending significant amounts of money on non-essential items such as gambling or reckless spending. This kind of spending can be regarded as a negative contribution by that party, reducing the overall property pool available for division and be able to be considered wastage by the court. This could negatively impact your entitlements in the final settlement. Maintaining financial discipline during this time helps to ensure a fair and equitable outcome for both parties. Do obtain legal advice. Financial separation can be a complicated and emotional process, particularly when significant assets are involved. While some individuals may consider managing the process independently, obtaining expert legal guidance early on can make a significant difference to both the outcome and your peace of mind. It's important to work closely with a family lawyer who understands the nuances of property settlements. Where appropriate, involving other professionals such as financial advisors, accountants, or business valuers can also be a good idea. By integrating financial expertise with family law advice, you'll be provided with greater stability and confidence about your financial future. Do take prompt action. Timing is crucial when it comes to finalising financial matters. Following a divorce, parties have 12 months to reach a property settlement, while former de facto partners have 24 months from the date of separation. Delaying beyond these timeframes can result in additional legal costs and the risk that the court may refuse to grant permission to proceed. At Nichols Family Lawyers, we specialise in high asset and complex property matters. We understand that navigating divorce is both legally and emotionally challenging, and we're here to support you every step of the way as you move forward into your next chapter.